Good day, this is Dimitri Lascaris coming to you from somewhere in South America on January 26, 2026 for Reason to Resist. Last week, a Canadian court convicted Yves Engler, a Canadian author and Palestinian solidarity activist, of 3 criminal offenses. The first offense is willfully obstructing a peace officer in the execution of her duty in violation of Section 129 of the Criminal Code of Canada. The second offense is intentionally attempting to obstruct, pervert, or defeat the course of justice in violation of Section 139(2) of the Criminal Code. And the third is making an indecent communication by means of telecommunication with intent to alarm or annoy a person in violation of Section 372(2) of the Criminal Code. Yves has not yet been sentenced. I understand his sentencing hearing is scheduled for early in March. But if these convictions survive an appeal, he could be sentenced to months in prison and possibly even years. In a moment, we're going to speak with Yves about the convictions, but first I'll summarize the history of this sordid prosecution. Before I launch into it, please remember to like, share, and with this video if you find it to be informative. And if you're not already a subscriber to Reason to Resist, we warmly encourage you to become one. We recently went through 122,000 subscribers after having launched this program in early 2024. And obviously, the greater our subscriber base, the broader our messaging of unapologetic resistance journalism. So with that, let's get into it. Now, as we've previously covered on Reason to Resist, the prosecution of Yves began in 2025 after Yves repeatedly criticized a fanatical Zionist influencer on social media. The influencer in question is someone by the name of Dahlia Kurtz. And here you can see her social media, or her X profile, where she proudly displays the flag of Israel's genocidal regime. Kurtz's social media commentary is an unending stream of anti-Palestinian racism, genocide denial, and anti-Muslim bigotry. More recently, Kurtz has become obsessed with Iran and has been cheerleading another war of aggression on that country. And here you can see a recent post in which she salutes the USS Abraham Lincoln, saying it's locked and loaded, and adds Shalom Khamenei. If I didn't know any better, I'd say that Kurtz just might be working for the Mossad. And as it happens, Kurtz recently, actually a month or so after Israel's or I should say a year or so after Israel's genocidal rampage in Gaza began, posted on X a photograph of herself with someone whom she identified as being from the Mossad. I have not been able to identify who this person is, don't recognize the face, but if anybody watching this video is able to say who that is, please leave that in the comments. In any case, she adds in this November 1st, 2024 photograph, we coincidentally met up in Israel whilst the Iranian regime is threatening to annihilate it, when in fact it was the genocidal Israeli entity, the only state in West Asia with nukes, that was threatening to annihilate Iran. And then she adds yet again that this was a coincidence with, you know, all those eyes beside it, suggesting or insinuating that in fact this was a planned meeting. Now, let me show you a couple of examples of Kurtz's social media commentary, just so you understand how odious she is. Here is Kurtz praising unreservedly the IDF. This was last year. I stand by the IDF and any Canadian who has ever served in the IDF. It doesn't just protect Israel, it protects the world. Yep, it protects Lebanon, Syria. It protects Yemen. It protects Iran. It protects even us here in Canada. That's the extent of fanaticism that we're talking about here, folks. And here's Kurtz accusing Palestinians of being thirsty for blood. She writes, so on a day when Hamas is parading dead babies in front of cheering Gazans, that's a lie. The Palestinian resistance was never parading dead babies. The UN makes a statement about desalination systems in Gaza because Gazans are thirsty, but desalination won't solve the problem. Yes, they are thirsty, but they are thirsty for blood. So at one time, she's implicitly denying that the Palestinians are being starved by Israel, a fact that has been documented amply by multiple human rights organizations, including Israeli ones. But she's also just broadly condemning them all as being bloodthirsty animals. And I could go on and on here, folks, but I think you probably get the picture. Now, during the genocide, Kurtz's vile posts kept appearing in Yves Engler's feed on X, where he happens to be very active. He was not following Kurtz on X and had no desire to do so, as I understand it. Rather, it appears that the algorithm was driving Kurtz's sick commentary into his feed. So he began replying to her posts with criticisms, which were at times quite harsh and justifiably so. Yves, as I understand it, never met Kurtz and never attempted to meet Kurtz. He never called or emailed her or attempted to reach her by telephone or email. He never threatened her, and there's no allegation that he did that either. As I said, he never even followed her on X. Despite all of this, Kurtz filed a complaint against Yves with the Montreal police. She accused him of harassment. The Montreal police then disgraced themselves by taking Kurtz's complaint seriously, and they decided to charge Yves with harassment under the criminal code. Yves was advised of the charge by a Montreal police officer, Detective Sergeant Francesca Crivello, and upon learning of the charge from Officer Crivello, Yves took to X, where he asked his followers to email Officer Crivello and urged her to drop the charges. According to the judge who convicted Yves, Officer Crivello then received nearly 1,900 emails from Yves' supporters in less than 48 hours. And here's what the vast majority of those emails had to say, according to the judge herself. You can see here, this is an extract, paragraphs 12 to 16 of her reasons. The decision is written in French, but the text of the emails that Officer Crivello were sent is in English, and I'll read it to you. It says, Dear Officer Crivello, the arrest of author Yves Engler for social media posts opposing Israel's genocide is an abuse of state power. The charges against the father of 2 young children should be immediately withdrawn. It's outrageous attack against freedom of expression that you would consider placing conditions on Engler, blocking him from publicly discussing the case against him. And just stopping there for a moment, initially Yves was told that he would only be released from detention if he agreed not to discuss the case against him. He ended up serving 5 days in jail. Ultimately, however, he was freed when that condition was dropped. So this complaint was entirely justified, as was evidenced by the fact that the prosecution dropped the condition. In any case, the message went on, advocates of apartheid and genocide have been seeking to mobilize police and court resources against critics of Israel's crimes. It's imperative that police not abuse their authority by assisting these efforts. Sincerely, X. Now, I want to point out a few things about this message. And again, this precise text, according to the judge, was used by the vast majority of those who emailed Officer Crivello. There is no obscene language in here. There's no explicit or implicit threat in here. There is no ad hominem attack leveled against Officer Crivello herself. What is essentially done here is that there is an expression of opinion about the injustice of the charges against Yves for allegedly harassing Officer Crivello. And the supreme irony is, of course, that the charges were ultimately dropped. Although Yves was prosecuted for the 3 charges involving the police officer, Officer Crivello, he was never prosecuted for harassing Dahlia Kurtz, something I'm going to come back to in a moment. And yet, despite all of that, the officer found, the court found that Yves had violated those 3 provisions of the criminal code. And I want to point out another part of this extract here up on the screen. In paragraph 15, you'll see the judge wrote, Elle reçoit tellement de courriels que cela en devient anxiogène. So the judge is basically saying here that she received so many emails that she became stressed. Now, as someone who lives in Montreal and whose taxes help pay for the salaries of Montreal's police officers, I have to say that I find this comment to be concerning. If Montreal's cops are stressed by emails like this, then how do they react when they are confronted, for example, by violent criminals? How can we, the people of Montreal, depend on these cops to protect us from threats such as those if they're stressed simply by a few hundred or 1,900 emails, politely worded, expressing opinions about the outrageousness of charges that were ultimately dropped? That's a question that I put to my fellow residents of Montreal And you may want to take this up with your local representative. At any rate, let's bring Yves into the discussion to talk about all of this. Thank you very much for joining us today, Yves.
Thanks for having me.
So, Yves, first of all, please tell us how you feel about the decision broadly.
Well, it's obviously a terrible decision. It has pretty bad ramifications. There was no case law on this, no example that the prosecution came up with citing email campaigns, polite email campaigns to the police leading to this type of charge. So it is a precedent. It definitely gives the police greater power to define communication / pressure as interference in their affairs and as harassment. That's very bad. It also is just another example of Zionist forces using the legal system to undercut those who are opposing Canada's complicity in genocide. The personal side to this, I don't think is very significant in the sense that I've spent 5 days in jail. I would be surprised if the sentence was anything more or anything significantly more than the 5 days I've already spent in jail, which, as I understand it, counts as more than 5 days when it comes to sentencing. But the big picture political ramifications, I think, are quite damaging, and we are going to appeal it. And I can see this case going, possibly all the way up to the Supreme Court, because in one sense, what we have on trial here is the notion of the Action Network email petition campaign and the right to engage in what is fairly common activist tactic of emailing government officials, corporate officials, reporters in some instances. And so here we have a situation where that has been turned into criminal activity, and not just on one front, interference in police affairs. There was it seemed like in the realm of the possible to be found guilty on that. The notion that I was harassing this Montreal investigator who I had one brief conversation with. I could not. The only time I ever saw her was when she testified. I actually didn't even know her name after it was stated to me. So if someone would just ask me who was the investigator, I couldn't even told you her name. So the notion that I was harassing this police investigator just seems so outlandish. But here we are with a judge coming down with that ruling.
Now, Yves, I've read the decision, and one thing I stood out for me is that it said absolutely nothing about the odious commentary of Dahlia Kurtz. It simply notes that Kurtz was pro-Israel and you were critical of Israel, and that it almost sounds like, oh, here are two people who have a legitimate disagreement about some issue, and it's not for the court to decide. She didn't actually say that, but there was absolutely nothing in there about her odious commentary. And as I mentioned at the outset, the charges against you for allegedly harassing Kurtz were dropped. I'm speculating here, but I suspect that they were dropped because the prosecution realized at the 11th hour that Kurtz, who would have had to testify for this prosecution to proceed, would have made an absolutely abominable witness. She would have been cross-examined by your able counsel, and he could have easily brought out her in that cross-examination, her anti-Palestinian racism and anti-Muslim bigotry. Do you have any insight yourself as to why these charges were dropped? Have you received any clues about that from the prosecution, or were they totally mum in the courtroom about why they never pursued them?
Yeah, they didn't explain why. I mean, I agree with you. That's my assessment as well. And I wrote that in the summertime that it would have been a spectacle, honestly, to see her on the stand, and especially considering how much she said that is just so odious, and even just simple questions like, why didn't you block him? If you felt harassed and you went to the police and you did this whole thing, why didn't you just block me from following you on Twitter? I mean, the whole game would be up. Just a simple that act. And she chose not to do it because I think it's pretty clear why, because this was all part of her bid to, turn the legal system. And I also should state that the police initially didn't move forward. She went to the police in the summer of 2024, and the police looked into it and decided it didn't warrant a charge or charges. And then a conservative candidate, the most prominent Zionist lawyer in Montreal, Neil Oberman, sent a letter about 4 or 5 months later, pressing this investigator in the hate crimes unit. Let's also understand this is the hate crimes unit of Montreal police, right? So I think if there was hate crimes engaged, clearly to me is Dahlia Kurtz's engagement in hate crimes towards Palestinians. But so Neil Oberman sends this letter to the police investigator, and the police investigator stated this to me, the first conversation or the only conversation we ever had, that she'd received this letter and then reopened the file. So I think they understood that this was reaching from the get-go, and they understood that this had some big ramifications, but they felt pressure. Maybe from the inside that we don't know of, but certainly we know from the outside with Neil Oberman, and they succumbed to that pressure. And then once I didn't just sort of bow down to the police, most importantly, it should be noted here, is with the condition. I was simply not willing to accept that condition. They said I could go to the police station, be in and out within 15 minutes if I accepted this condition. I was like, there's no way you're going to charge me with harassing Dahlia Kurtz and then also say I'm not allowed to talk about the fact that I was charged with harassing Dahlia Kurtz. And so when I pushed back by writing about it and by promoting this email campaign, the police basically saw this as a challenge to their authority, and they doubled down. And they, subsequently the condition was thrown out. The judge, we had jurisprudence that said this was basically an illegal condition, and then the charges themselves were thrown out. But then they continued with this business of me targeting the police, and they got a judge, to agree to it. So I don't know why they dropped the Dahlia Kurtz charges. I mean, I wrote about it multiple times, and I kind of went at that question of like, this is going to be a spectacle having her on the stand, and I think there would be a lot of people who would have wanted to come to the court to watch the questioning of her. So that's my presumption of why they dropped the Kurtz charges.
Yeah, just to go back to something you said a moment ago, like you, Eve, I have the misfortune of seeing her commentary in my X profile. I could block her, but I haven't, just because she does have a significant following. I do want to be aware of what she's saying out there, but I don't follow her. And when I do see her stuff pop up in my feed, I, on numerous occasions, have said, have I mentioned recently that you're a genocidal racist? And I've probably done that 10 or 15 times. And she hasn't blocked me either, so she could easily do that. For some reason, she's I guess she wants to be told what I think about her. In any case, I want to go to paragraph 52 of the decision. I'm not going to actually show our audience it because it's in French, and I suspect that a lot of people who are watching this don't speak French. But in essence, what the judge says there is that your supporters who wrote to Officer Crivello had no idea about the basis of the charge against you for harassing Dahlia Kurtz. What do you say to that, Yves? Do you think your supporters had no idea about the basis of the harassment allegation against you?
I think the people who wrote all understood the broad context that I am an author and activist, and there's a genocide going on, and many of them were very aware of Kurtz herself, because she is quite prominent on X and other platforms. and they also knew the context that Zionist forces have been abusing the legal system to shut down criticism of Canadian support for genocide. And the notion that this judge, without any evidence, it just takes it for granted that everyone is just like I don't know what they're just
an ignoramus.
Yeah, whatever I say, they do. You know, it's quite remarkable because a lot of the whole decision hinges on this notion, right? So, like, why weren't it was about 4,000 people, over 4,000 people that ultimately messaged. Why weren't all of or many of, you know, or maybe anyone who shared it? You know, I wasn't the only one who shared the action alert. I presume dozens of people shared it on their Facebook, on their Twitter, probably via email or other mechanisms. And why weren't any of those people charged with harassing or interfering in police affairs? And so the judge makes...
You didn't send the emails yourself, right? These were 18 and 19. She's like denying. Sorry, just to say, I think she's like denying the agent, not only the intelligence of these people. You know, you didn't have any command over them. You asked them to send it, and they made a decision on their own to send it, and ultimately they were the people who were responsible for sending it, I would think.
Exactly. And I may have sent an email. I'm not even sure if I sent an email. So it's complete denial of the agency of all these individuals. And there's, again, no evidence of, you know, this. The Crown inferred that it was kind of a weird argument because they kind of inferred, they basically said that I was responsible because it was shared on all kinds of big platforms that I have, and that's why people emailed. But then they also sort of inferred that maybe I sort of generated the emails in some kind of bot form, which is absolutely unequivocally untrue. There's zero evidence of that, and it's just not true. And yeah, these people emailed on their own volition because probably a mix of they know who I was, they knew who Dahlia Kurtz was, and they knew what she's been up to, and they knew the broader political context. And on the face, you don't have to know like all of the intricacies of every legal element to sniff that this was like an odious attack, right? Like there's nothing out there besides a claim that I responded to her on X. There is no one claiming that I went to her house, that I emailed her, that I, you know, anything. There's no claim out there. Dahlia Kurtz has never made that claim. The police never made that claim. So the people who hear my description of what happened and then take action, I mean, they had the right to do it, and they did it. So that judgment is pretty unbelievable that the judge was puts that so clearly, and also that she doesn't deal with the charter question. She doesn't deal, like, she frames it as if it's all just sort of like a police, kind of the difficulty for the police officer for the morning. And the police even said they had a filter on her email by 9:15 the next morning. So I don't know what she started at, if she started at 8 o'clock, 8:30 or 9, but by 9:15 they had a filter. And so subsequent emails mostly went into the filter. And so even the consequence on her inbox was more or less dealt with within an hour, somewhere between 45 minutes and an hour and 15 minutes into her day. So they've turned something that's fairly minimal into this big notion of like her whole day or days of work were, you know, subverted or whatever.
Yeah. There was another thing that really struck me about this decision is the judge. I think it seems like your lawyer argued, and you correct me about this, but I wasn't in the courtroom, but I'm inferring this from the decision, that your lawyer argued that the opinion that all of these people expressed in their emails to Officer Crivello, that the charges were outrageous and baseless, was ultimately proven to be correct because they dropped the damn charges. And the judge goes through these hoops to try to come up with other reasons why they might have dropped the charges, like, oh, they didn't have the resources. They decided that they should apply their limited resources to some other prosecution or something. I mean, even if she's correct that there are possible other explanations for why they dropped the charges, the mere fact that they dropped the charges at least lends legitimacy to the opinions that were being expressed by the people in these emails. I mean, it's not like you asked people to say things that were beyond the pale, that could find no basis in fact or in reason, because they dropped the damn charges. I mean, what are you to make of all of that? Did your lawyer in fact argue that the dropping of the charges was vindication of the people who sent that email?
He did. He did, and I think that's the correct assessment. I mean, you're saying that these people didn't know the law, and in fact, they ended up being more correct in the law than the investigator, both at the level of the fact that once the condition got brought before a judge, the judge said, no, that condition's not acceptable. And the prosecution themselves decided it wasn't even worth bringing the charge before a judge because the odds of getting a conviction were so low. So it seems pretty clear that the more lawful, sensibly lawful people were the people sending the emails than the investigator or right. So that argument was made, but the judge, it was very clear to me from the moment we started the trial, the judge was very hostile. If you read that decision, she suggests that if the Dahlia Kurtz charge wouldn't have been dropped, that what I took from how she was framing it, she would have probably even convicted me on the Dahlia Kurtz charge that was ultimately dropped. So this judge seemed very hostile. Who knows where that comes from? There is clearly a very high degree of respect for policing authority within the legal system, and this judge, to my mind, this was a display of that is pretty crude.
Yeah, the judge, by the way, her name is Karine Guiguer, and I did some research on her background, and the only thing I was able to find, not going to pretend it was exhaustive research, but I spent a few minutes trying to find out something. And usually, I've done this because I myself am a lawyer, I've done this countless times, and usually you can find a pretty detailed information about judges appointed to the superior courts. And the only thing I was able to find was that she was a lawyer working for legal aid, which, one would think that lawyers who had a career working for legal aid would be sympathetic to the accused and not so extraordinarily deferential to the cops. Do you, Yves, know anything more about her background? Any clues as to why she was hostile to you?
I heard that her partner's a prosecution lawyer, so that would, lead to some, greater connections with police and sort of a certain level of respect to the police like that. But I don't know anything. I don't know anything more about her and, what the sort of political motivation for her decision. I can say that there's a lot of attacks against me personally out there, right? So how does that impact a judge's decision? I don't know. The fact that the NDP denied my candidacy during a period when the judge was deliberating, the fact that there's all this kind of attacks from the zionist groups out there against me and others. I don't know how that plays into a judge's decision. And then there's clearly a climate, just more broadly, a climate of saying that those who have been opposing genocide are the racists or are the harassers or are nuisance to the public and all this kind of stuff. So that's obviously somewhere in the background. I think that's not just somewhere in the background. The fact that it was a hate crimes investigator from the police that is the one who did this in and of itself really demonstrates the role of this sort of anti-Semitism kind of smear in the background of this, and then how the judge moves forward with that is a little bit unclear to me. But that seems like that's part of what's in the background here, at least.
Yeah. Broadly speaking, the decision should be based entirely on the evidence before the court. And maybe that's the case here. I mean, I can't, I don't pretend to know what was in the judge's mind or what other information the judge might have had about you. But I will say this, and I'm not saying this specifically about this case because I just don't know. But in my experience of practicing law for over 30 years, it's my strong impression that judges are oftentimes influenced by a lot more than the evidence that is before them. For one thing, and I feel very confident in saying this. Again, I'm not saying this about this particular judge or any particular judge, but I'm talking about the totality of my experience. I have no doubt that judges are influenced by their own political ideology and the decisions that they make. And I think it would be, I even learned that in law school. It's one of the first things they taught us, at the University of Toronto, that whatever they say, judges are human beings, they're political animals, and invariably this will affect their decision-making. And I can confirm from 30 years plus of practice that that is absolutely true. In any case, I want to go back to something you said a moment ago. You referred to the Charter. For those people who are not familiar with the structure of the Canadian legal system, Yves was referring to the Canadian Charter of Rights and Freedoms, which is the Canadian version of the Bill of Rights, the U.S. Bill of Rights, and it has constitutional status. So courts can use the Charter to strike down laws, narrow down the interpretation of laws, and provide other types of remedies. And of course, like the U.S. Bill of Rights, our Charter of Rights and Freedoms protects the right to free speech. And Yves, maybe I missed it. I read the whole decision. I read parts of it a couple of times. I didn't see any reference to the Charter in that entire decision. Did this come up in the courtroom? Was the Charter mentioned?
I believe it was mentioned. I have to check that. I believe it was mentioned. My lawyer didn't focus in that direction. Focused more on the notion of petitioning a state official. That was kind of the direction that was focused on. But I believe the Charter was raised, and freedom of expression was certainly raised by the other side quite aggressively. They kind of went at that, and they framed that there's always restrictions on freedom of expression. So it was definitely raised. And as you point out, the judge just ignores that and goes at a very narrow sense of like the impact this had on the police's operations, on the police's vision, versus what are the big picture political impacts in terms of freedom of expression. So that to me seems one of the areas that where we can pursue the appeal on. Mm-hmm. But yeah, it was raised, but not aggressively by my lawyer.
So you mentioned your lawyer focused on petitioning public officials. Could you talk to us about what you believe the impact of, if this decision were to stand? I think and hope it won't, but who knows in today's political climate. What are your thoughts about how this decision will impact petitioning public officials, and why is this an important issue?
Well, to me, what's most clear cut is that this is very bad precedent vis-a-vis the police specifically. The police have just been given far greater ability to define any sort of communication that they don't like as either harassment or interference in their affairs or obstruction of justice. And my understanding is that obstruction of justice has generally a pretty different interpretation than emails being sent, because I myself have been engaged in calling like jail support. So people have been arrested at demonstrations. Multiple examples in Toronto I can think of where they've asked people to call the police department and ask for the person to be released. I can remember multiple times myself making those phone calls. One time in particular, I really remember how the police officer seemed to be kind of like annoyed that we were calling. And what I took it was that I wasn't the first person who had called, and they'd gotten multiple calls and were sort of annoyed. Now, that by this decision, to me, email is much less than phone calls, right? You can make a case that by calling to call for the release of somebody, in detention, that you're jamming up the police line and undercutting their ability to get other tips or whatever, right? So you can make a stronger case for that to be obstruction with police affairs or harassment than you can with regards to an email campaign. So that to me is very clearly negative. Now, as you go broader, how does this what other departments or other institutions fall under this, right? Like, I mean, email petition campaigns are common. Like I mentioned this about, Honest Reporting Canada, which is a Zionist FLAC organization. They regularly have email campaigns targeting journalists, sometimes like as sort of low down on the journalist totem pole as like Concordia students, Concordia Link journalists, right? So they'll flood the box of a journalist at a student newspaper, who of course has way less power than a police investigator would have.
And less resources.
And much less resources to like put in a filter. Like the SPVM, the Montreal Police's IT department, had a filter in on her email very quickly, as they admitted in court. So the impact on restricting that, and why would I don't know, let's say somebody at the municipal government that's in charge of who knows what, I don't know, the water department, and let's just, there was some scandal at the water department in the Montreal municipal government, and there was some effort in an email campaign saying, hey, take the corruption case, or what, investigate this corruption case seriously. Maybe they can now say, hey, based on this precedent, that's harassment, that's interfering in my, I guess is not the clear law about obstruction of justice, but the harassment or indecent communication, and seek to target the organizer of that email petition campaign. So that seems also a possibility that comes out of this precedent. And then I guess at the bigger picture, as I've stated, this is just this emboldens the Zionist forces to further their lawfare efforts, which are not always designed to have a victory. In this case, they have at least the first step of a victory, but not designed just to have a victory, but they're designed to suck the resources of the anti-genocide forces into the legal system, and so in that sense, this will embolden CIJA, and who's already been boasting about it on Twitter, the Center for Israel and Jewish Affairs, the lead Zionist organization in Canada.
Yeah, I just want to point out that this is important to understand what the potential impact of this decision is. So I mentioned you were convicted on 3 charges. The first 2, which are based on sections 129 and 139 of the Criminal Code, are confined to what the Criminal Code describes as peace officers or public officials. And a peace officer is basically, under the Criminal Code, someone who has law enforcement powers, law enforcement responsibilities. A public official is somebody, basically works for the state, and who may not be, strictly speaking, a peace officer, but has powers that are analogous to, I'm paraphrasing here, those of a peace officer. And I'm just going to put up on the screen so people can see section 129 of the Criminal Code. Everyone who resists or willfully obstructs a public officer or peace officer in the execution of his duty, or any person lawfully acting in aid of such an officer, is guilty of blah, blah, blah. So one might argue, and the other section I just mentioned, I think it's 132, that uses similar language. So one might argue that those 2 charges, they're really confined to situations where people communicate with a law enforcement official. But there was a 3rd charge on which you were convicted, and I want to just put that one up on the screen to make a point about the scope of that charge. And this is the one, the harassment charge. Everyone commits an offense who, with intent to injure or alarm a person, It doesn't say peace officer. It says a person conveys information that they know is false, and so forth. And then this is the pertinent section, subsection 2. This is the one they applied to you. Everyone commits an offense who, with intent to alarm or annoy, again, a person, makes an indecent communication to that person or to any other person by a means of telecommunication. So the point I want to make here is that this third charge under section 372 is not confined to peace officers. This could be applied to any person, anybody who works in the government, a member of parliament and so forth. So I think it's important to understand that this decision doesn't simply have precedential value for how the public interacts with cops. It actually has precedential value if it stands for public interactions with any government official, including, for example, your member of parliament. So, people, particularly if you live in Canada and you value the right to speak freely, I think you should be very, very concerned about the impact of this decision. Now, Yves, I want to ask you about a couple other things before we conclude our discussion today. The conviction has been widely covered by the Canadian corporate media, and I'm going to put up on the screen here the article published by the Globe and Mail. This one was published, I think, on Friday of last week. And the author is Eric Andrew G. The Globe and Mail, a lot of people kind of regard it as Canada's paper of record. I found this article, Yves, to be surprisingly balanced. But there have been other articles written about you, including by, the Montreal Gazette, which is part of the post-media empire, a fanatically Zionist newspaper, the largest newspaper publisher in Canada, actually. Just your overall thoughts on the corporate media's coverage of this.
Well, I should note that this journalist from the Globe, he actually attended the full hearing back in November, and then he was there for the ruling at court on Friday. So he actually understands like what this is all about, right? This is just emails. So yeah, I agree with you that his coverage was decent. It focused more on the issues rather than sort of the demonization of myself. And but that wasn't the case with the Montreal Gazette article that was published after the ruling. They said they used a word language that I arranged to fill her inbox up with emails, which was like, of course, asking people to take their voluntary action of emailing the police to this petition website. The arrangement, they kind of acted like I had some great power where I took people's inboxes and dumped them in the police officer's inbox. But in the Journal de Montréal article was even worse. So yeah, there is the coverage has been pretty bad. It has been fairly extensive. It was published in the National Post ran it in the paper with a photo. All these papers ran it in their Saturday editions with photos, and so it's kind of got tied into. I think people understand that this case itself is pretty weird. Like we're talking about emails to police, right? And to make that some big criminal thing, that's weird. But then it's also got caught into the attacks against me and the demonization of me with regards to the NDP leadership race in part, and the sort of storyline there. And then also like I said, the Zionist organizations have been applauding this decision, and there's all these people who really dislike me on the right who have been crowing about this. So I think the media's reaction to it is in part a reflection of that power dynamic. And let's just remember here, to go big picture, 2+ years into this lawless apartheid state committing a live stream genocide in Gaza, after it's bombed 6 or 7 countries in the region over the past year, it's still those who support those crimes that are viewed as the victims, right? That's how kind of confused Canadian political culture is. even as the public opinion has shifted, but the broad media dynamic is one that, like, Israel's the victim, and the morally righteous thing to do is to support Israel in bombing every different country in the region, and driving out or killing basically every Palestinian in Gaza. And so this case gets filtered through that lens.
And the last thing, since we're on the subject of right-wing people with sympathy for the genocidal sadistic entity, a character by the name of Carl Belanger apparently has been praising the decision, and you commented on X, a former director of NDP is happy police gain greater rights to criminalize email campaigns. Can you tell us about this guy, Carl Belanger, and why you posted this comment about him on X?
Yeah, he actually did a whole story about it, flushing it out a bit more. And he was the former director of the NDP. He's in charge of the Douglas Coldwell Foundation, which is this NDP aligned foundation in Ottawa. He was press secretary for Jack Layton. He was a senior advisor for Thomas Mulcair, previous NDP leaders. And he basically posted this Journal de Montréal article that was very hostile to me and effectively supportive of the judge's decision. And he said basically, well, this decision justifies the NDP excluding me from the leadership race. And effectively, he's lauding the judge, saying that emailing the police is criminal activity. I think this speaks to how the NDP brass, how much they are power worshipping, pro genocide in their outlook, right? And this is not the first instance of seeing that, but to publicly basically boast about a judge ruling that emailing the police is harassment or obstruction of justice. If you are in a union, if you are in a social movement organization, if you're in a feminist group, you definitely do not want to be giving the police and or political officials greater power to claim that email petition campaigns are harassment or obstruction of justice. Let's be clear. The NDP, what the NDP says it represents, absolutely all of the forces within the NDP, and quite frankly, way into the Liberal Party and even segments of the Conservative Party. If you have a basic notions of liberal democratic norms, this is a bad ruling. And so the former director of the NDP sort of using it as a way to justify what was a bad decision by the NDP to exclude my candidacy is just very telling of the state of Bélanger's politics, and I think, unfortunately, a bit broader in terms of the brass of the NDP.
Yeah, and for those of our audience members who are not from Canada, NDP stands for New Democratic Party. This party is claimed by the corporate press to be left-wing. The more kookier people on the right in the corporate press actually say it's extreme left-wing. As a leftist, I will tell you, I don't think that any true leftist could support a decision such as this and should be denouncing it without hesitation, whatever they may think of you personally, Yves. I mean, this is just a frontal assault on our, as your lawyer eloquently argued, our right to petition public officials in a supposedly democratic society. Before you go, Yves, litigation is expensive. You've got a long battle ahead of you in the courts. How can people assist you if they're minded and able to do so?
Yeah, I have started raising funds, and we've been able to raise a few $1,000s to prepare for the appeal. And on my website, yvesengler.com, yvesengler.com/donate. I am asking for financial support because we have 30 days to appeal. And if that, hopefully that will work, of course, but this might play itself out for many years. But I definitely, it's going to be expensive. Even just getting all the transcripts and stuff is expensive. And we need to organize a proper appeal because, again, I'm not seeing a big possibility of personal impact. Like I find it unlikely that I would go to jail for any more time than I'd already been. But the political impact of this is very damaging. So I want to fight this all the way, and actually hopefully get some sort of precedent that expands our ability to petition state officials.
Well, we'll conclude it there, and we thank you. And I'm sure I express this on behalf of many of our people, the people watching our program today. We thank you for your steadfastness and your defense of our right to speak freely. And we're signing off today from somewhere in South America, in Montreal, for Reason to Resist on January 26, 2026.